Hello, this is R.J. Deacon, reading the Supreme Court of the United States opinion syllabus in BNSF Railway Corporation versus Loos, certiorari to the United States Court of Appeals for the 8th Circuit. Argued November 6, 2018. Decided March 4, 2019. Respondent Michael Loos sued petitioner BNSF Railway Company under the Federal Employers' Liability Act, FELA, for injuries he received while working at BNSF's rail yard. A jury awarded him $126,212.78, ascribing $30,000 of that amount to wages lost during the time Loos was unable to work. BNSF asserted that the lost wages constituted compensation, taxable under the Railroad Retirement Act, RRTA, and asked to withhold $3,765 of the $30,000 to cover Loos's share of the RRTA taxes. The District Court and 8th Circuit Court rejected the requested offset, holding that an award of damages compensating an injured railroad worker for lost wages is not taxable under the RRTA. The Supreme Court held a railroad's payment to an employee for working time lost due to an on-the-job injury is taxable compensation under the RRTA. In 1937, Congress created a self-sustaining retirement benefits system for railroad workers. The RRTA funds the program by imposing a payroll tax on both railroads and their employees, referring to the railroad's contribution as an excise tax, 26 U.S.C. Section 3221, and the employee's share as an income tax, Section 3201. The Railroad Retirement Act, RRA, entitles railroad workers to various benefits. Taxes under the RRTA and benefits under the RRA are measured by the employee's compensation, which both statutes define as any form of money remuneration paid to an individual for services rendered as an employee. That's sections 3231E1 and 45 U.S.C. section 231H1. The statutory foundation of the railroad retirement system mirrors that of the Social Security system. The Federal Insurance Contributions Act, FICA, taxes employers and employees to fund benefits distributed pursuant to the Social Security Act. Tax and benefit amounts are determined by the worker's wages, the Social Security equivalents to compensation. Both the FICA and the SSA define wages employing language resembling RRTA and the RRA definitions of compensation. The term wages means all remuneration for any service of whatever nature performed by an employee. See 26 U.S.C. section 3121A and B for FICA, and see 42 U.S.C. sections 409A and 410A for the SSA. Given the textual similarity between the definitions of compensation and wages, the decisions on the meaning of wages in Social Security Board versus Nirotko and the United States versus Quality Stores Incorporated inform this court's comprehension of the RRTA term compensation. In Nirotko, the court held that wages embraced pay for active service as well as pay received for periods of absence from active service, 327 U.S. at 366, and concluded that back pay for time lost due to the employer's wrong counted as wages. In Quality Stores, the court held that severance payments qualified as wages taxable under FICA. In line with these decisions, the court holds that compensation under the RRTA encompasses not simply pay for active service, but also pay for periods of absence from active service, provided that the remuneration in question stems from the employee-employer relationship. Nirotko. Damages awarded under FELA for lost wages fit comfortably within this definition. See BNSF versus Tyrell. If a railroad negligently fails to maintain a safe rail yard and a worker is injured as a result, the FELA requires the railroad to compensate the injured worker for working time lost due to the employer's wrongdoing. FELA damages for lost wages, like back pay, are compensation, taxable under the RRTA. The Eighth Circuit construed compensation for RRTA purposes to mean only pay for active service, but this reading cannot be reconciled with Nirotco and quality stores. In addition, the RRTA's pinpointed exclusions for certain types of payments for time lost signal that non-executed pay for time lost remains RRTA taxable compensation. Loos contends that compensation does not include payments made to compensate for an injury. This reading, however, is at odds with Nirotco, which held that wages included back pay awarded to redress the loss of wages, occasioned by the employer's wrong. Loos also argues that the exclusion of personal injury damages from gross income for federal income tax purposes, see 26 U.S.C. section 104A2, should carry over to the RRTA's tax on the income of railroad workers. The RRTA, however, uses the term income merely to distinguish the income tax on an employee from the matching excise tax on a railroad. Further, Congress specified not gross income, but employee compensation as the tax base for the RRTA taxes. Congress did not exclude personal injury damages from compensation. The decision is reversed and remanded. Justice Ginsburg delivered the opinion of the court, in which Chief Justice Roberts and Justices Breyer, Alito, Sotomayor, Kagan, and Kavanaugh joined. Justice Gorsuch filed a dissenting opinion in which Justice Thomas joined. Thank you for listening. If you'd like to get a hold of the podcast, we can be reached at rhodesscholar80@gmail.com. That's ROADS and 80. Thank you.